Hello and welcome once again to Minds That Matter. I'm your host, James Thomas. Welcome to summer. And I am here with H. Reed Cosper, who is the Rhode Island mental health advocate. Would that be a fair way to make that statement?
That would be accurate.
Okay, and welcome. Glad to have you back. Reed's been here a couple of times, and we're very glad to have you back.
It's always a pleasure
to
be on this program. I go to YouTube myself and watch it.
There you go. There you go. Well, that's good because we are streaming on YouTube. Many of our shows are there. Alan was able to pull that off, which is great. So we're not only here on public access, but we're also on YouTube too. So that's a good plug for us.
You've got more high tech than I have.
There you go. Well, as I had said while we were waiting for the show to start, we had some questions about. We were talking, some of the members of the staff here were talking about forensic hold status, how that works or doesn't work in terms of when a person is mentally ill and they commit a crime. They, in theory, could be on forensic hold much longer than the general population who commits the same crime but serves a specific sentence and then the sentence flattens and they're out of prison. But the person who's on forensic hold could stay on that hold longer than what that sentence would have been for. Is that correct?
That is correct. That is correct.
Now, our concern is and I know that you've been interested in trying to get those two sentences to be in line with each other, that if you're in a forensic hold and you committed an armed robbery and were supposed to do 10 years, you'll do 10 years on the forensic hold as if you had done 10 years at the ACI. But that is yet to happen?
Oh, yeah. In fact, I wouldn't say that I've been active in changing it because we're not at a point in time where people are willing to have that conversation.
Oh.
So the status quo now and for the foreseeable future is that a person who has been adjudicated not guilty by reason of insanity will be facing an indefinite detention in the state mental hospital, and beyond that, an indefinite detention under forensic status, even if they get out of the hospital and go to the civil wards or a group home or life in the community. The way it exists now and will for the indefinite future is that it rarely ever goes away, regardless of the length of your sentence.
Is it specific to NGRI that you are a forensic hold status, or could it be that you were just found incompetent or you were not restorable, or what areas do forensic holds stand?
Well, actually, the fact that you refer to you have the expression forensic hold is it's a little bit of a simplification. It's what that's the term that providers use in the community, and it doesn't do justice to the details of how this happens. So let me just take a second.
Yeah, fill us in.
The word forensic hold is almost too generic for use in this conversation. So I'll just describe to you. When a mentally impaired person is arrested for a crime and it becomes visible to the judge, which is not always happened.
That's right.
Lots of very impaired people wind up falling into prison where their mental impairment causes them to be treated like disruptive inmates instead of mentally ill people. But when an impairment becomes visible to a judge, it's pre-trial, when the person still has the presumption of innocence, the first thing that happens is a competency evaluation, and the person is that person is evaluated in the prison by a psychiatrist, and if determined by that psychiatrist to be not competent, he is then transferred to the Eleanor Slater Hospital, which has a wing called the forensic unit, which is a high-security locked wing with specialized staff. And it's physically horrible because it's from the 1940s, and we need a new one.
It's very small also.
It's 20 beds, and that's down from 60 beds as recently as the 1980s. And that's a sad thing because you can't run a prison. This is our prison mental hospital, and a prison with 3,000 inmates and 400 mentally ill people should have 100 beds, not 20. And that's beyond my wildest dreams too, I might say. But we are in the works is the idea to modernize the forensic, to move the forensic unit into a more modern building that will be remodeled to be high security and specialized unit, and that'll be a good thing, but not a lot more beds, which is not a good thing.
Right.
Okay, so when a person goes in that first phase of a prosecution to the forensic unit, we call that a forensic hold, because they are detained at the Eleanor Slater Hospital until an order of the court authorizes their move back to prison or their discharge to the community. So they're held, they're detained. If a person has been found competent and then goes to trial and pleads a defense of insanity, if that defense prevails, if a jury finds, or a judge finds that person so impaired by a mental illness as not to be able to tell right from wrong. That's the ancient standard. The modern word. The modern words are slightly different, but too impaired to tell right from wrong, then that person is committed to the custody of the mental health department, and that too is called a forensic hold.
Okay.
And when the person spends a decade in the forensic unit being treated for their illness, they sometimes move up. Well, they almost always move through the mental health system. At some point they don't need that level of restraint, and they're moved to the civil wards by the order of judge because they're on a forensic hold. There's that word for you.
Okay.
And some people, after years in the civil wards, are stable enough to move to the community, and they're moved to the community still with a forensic hold. And so in that context, forensic hold really means that you're subject to the order of a judge under the statute that pertains to criminal insanity. And that is Chapter 5.3 inside Title 40.1 of the General Laws of Rhode Island. So forensic hold is generic, and I think it would be very useful if forensic holds were to terminate at 2/3 of the maximum sentence.
Which is the same as parole would start, right?
Well, it's the same as not competent.
Okay.
If you're arrested for criminal action, the classic case was a guy who got involved in a shootout with the police back in the 1980s, and he survived after being shot in the head, and he lost a big part of his brain, and he was never competent to face trial. But of course, he's charged with assault with intent to murder because he was shooting at the cops, and that could be 30 years in prison. I think at the time, and the Supreme Court of the United States declared that no person who is permanently not competent to face trial can be held more than 2/3 of the sentence.
Would that be also equivalent to unrestorable?
Unrestorable, right?
Yes. Okay.
And if you cannot be restored to competence, and this guy could not be because of his brain damage, at the end of 2/3 of his sentence, by a ruling of the United States Supreme Court, the state had to discharge him, and the state went to great effort to discharge him safely. And upon that discharge, one of the state's options is to commit him to psychiatric treatment against his will through the civil courts, through what's called the mental health court, under the mental health law. So you just change chapters. You change from Chapter 5.3 to Chapter 5 of Title 40.1. And so, and there is an important distinction between one and the other. If you have a forensic commitment, your liberty will always be subject to the order of a criminal court judge. If you're civilly committed, your liberty is managed by a district court judge under the mental health calendar, under the mental health law. And I am a great proponent of using the mental health law. It's quite effective, so it's not absolutely necessary that people who have a forensic hold, a forensic commitment, need to be held that way for all their lives, because we have a secondary level, in fact, a much more common level of committing people to compulsory treatment without using the criminal justice system. And so my hope would be that someday we will limit insanity commitments in the criminal system to 2/3 of the maximum sentence, and then in every case where it matters, where the person still needs supervision, we civilly certify them.
Now, is that related to the Woodmansee case in this regard, that he's been remanded to Eleanor Slater Hospital, my understanding? But but he hasn't been committed. Isn't he going voluntarily?
Yeah, that gets us another turn of the page, actually. I'm reluctant to talk about the Woodmansee case in particular because I'm fairly sure that a day will come when my office represents him. Mm-hmm. But generically, speaking in broad strokes, any person who is committable under the mental health law has the option of voluntarily engaging in treatment. Mm-hmm. It's a preference that's written in the statute, so that if I mean, I've got a really good example. In my world right now is a young man who became psychotic, very ill, and he killed an animal, and his family was very concerned about public safety, and they asked that he be committed under the mental health law. Mm-hmm. And when it was discussed with him, he was told that before we can commit you, we have to offer you the chance to be voluntarily engaged. And he said, great, I too share your concern about mm-hmm. public safety. Right. And he signed a voluntary. And so now he is engaged in treatment on a voluntary basis. If a person tries to walk away from the voluntary agreement, the mental health system has the absolute legal statutory right, and if you want my opinion, duty, to then commit the person against his will mm-hmm. in cases where public safety is significantly threatened.
If there's an imminent danger to self or others, or
not
judgment's
imminent.
Impaired?
Not imminent.
Doesn't even have to be.
No, imminent. Imminent is the word we use for emergency commitments, but those are that's for 10 days, right. When it's imminent. But if there's a history of, say, committing a homicidal act mm-hmm. while mentally ill, you can be committed under the civil system forever. The question is whether by reason of a mental illness, there's a likelihood of serious harm if you are unsupervised.
Okay.
Now, the supervision is much more humane than supervision in a penal institution, let me tell you. Mm-hmm. But it can be every bit as comprehensive. And I do have occasional clients who are committed always, and not necessarily homicidal acts. I have a client who, when he is psychotic, he commits acts of self-mutilation. Mm-hmm. When I met him, he was missing a third of his arm because he stuck it in a fire while sick, and that particular client was permitted to sign a voluntary, and he went months and months as a voluntary patient. He got sick. And when they observed symptoms, they immediately moved to commit him again because everyone knows he will do some terrible act upon himself. Mm-hmm. And I'm really, forgive me for just talking on in a stream here, but
this is fine.
I'm glad to have this conversation because we could use some progressive change in this regard. I mean, it starts with shortened forensic commitments to be no more than 2/3 of the maximum sentence. Use the mental health law more aggressively to follow people who present a risk to public safety and commit them, and use our continuum of care more effectively. The facility of last resort for people who are mentally ill and dangerous is Eleanor Slater Hospital, and admission to that hospital is not very fluid mm-hmm. Because they've got the idea since 1995 that admissions are up to them, that they're not really a facility of last resort, that they're just a freestanding hospital that gets to pick and choose, which leaves us with only one facility of last resort we call a jail, mm-hmm. and that's no one. I don't think the people who wrote the mental health law ever dreamed that there would be one facility of last resort and it would be a penal institution. Mm-hmm.
Which also has the largest grouping of mentally ill folks in one area in the state.
Right, it's our largest mental health facility, mm-hmm. and that's a terrible, in the 80s, when they talked about the campus on which I work, they would say, we're going out to the hospital. And now, in the 21st century, they say we're going out to the prisons.
Right.
Because the prisons are now more than, I'm not going to guess, 60-70% of the buildings, and the hospital is far less than that.
Right.
It's I probably 15% of the buildings, and that's a public policy decision that's been made without a whole lot of debate, driven by money, without much reference to law, and the rule of law. If I may talk like a lawyer, because I never, 30 years ago, I'd been I never would have dreamed I'd be spending my day and dreaming at night about the glories of the rule of law. But I do indeed.
One other piece of the forensic process, I remember folks that we've seen, they have to be seen by the Forensic Review Board, correct? Is that still operational?
I think operational is not really a good word for it, because there are so few forensic commitments that it's really it's kind of I'm going to say, in my view, it's rather informal. Okay. When there is a forensic patient who needs to be reviewed, they'll slap together a group of people that served the last time, 7 years ago, and it's true from the perspective of a provider. You get the impression there's this august body called the Forensic Review Board,
but it's not.
No, it's not august. It's a bunch of clinical and administrative people at a pretty high level that get together and meet. And I've left something out of this piece too. The amount of time a person spends in the forensic unit is, in many cases, less related to his stability as a sick person than it is to the severity of the crime he committed. We have a guy at the forensic unit who's been there for, I think, more than 20 years, and he's very stable, and and could live in the community, committed to treatment. In fact, forensically committed. He could live in. He's a candidate for group homes. He's a very impaired guy, but his symptoms have been managed for 20 years. But he killed children, and public opinion would trump the rule of law.
Right.
And you can't. I'm not angry about those are larger questions. But I do want to say, whether you're mentally ill or not, if you've killed someone, the state has a right to follow you for the rest of your life. I would even say that's true if you killed someone while you were drunk driving a car. The state has the right. Doesn't necessarily do it, but the society has the right. We don't want to engage in vengeance, but if you take someone's life, I think you just bought a ticket to be supervised for all your days.
Would that mean after serving 2/3 you'd be eligible for parole, but not necessarily get parole?
Well, parole is not the word. You'd be eligible for the termination of a forensic commitment. Okay. But then you'd get civilly committed. Okay. If they chose to. I mean, that would be if I was director of mental health, I would pretty much, my written policy would be anyone who's mentally impaired and commits a homicide offense is probably committable for life. Because to remind you the standard, mentally ill in need of treatment whose unsupervised presence would create the likelihood of harm. I think it's very difficult to say that anyone who commits a homicide while mentally ill could ever be safe unsupervised. It is a chronic illness after all. And that also leaves the eternal truth that in the 21st century, someone who's that ill, who's on medication, is not that dangerous. And that's the supervision part. This is, in a way, our mission is to educate society that while a person who is psychotic and disorganized can be strange and sometimes strange, bizarre, dangerous, I guess in that ascending order, compulsory treatment when necessary can stabilize that person to certainly eliminate the danger piece. Right. And I'm not going to say that's uniformly true. Right. But I'm going to say that I wish society deferred a little more to clinicians who have experience in this regard.
No, one thing that I've always had questions about, the differentiation between what I'll call a crime of passion, where someone commits a crime against a family member or a loved one, versus what I'll call a generalized crime of, I heard command voices telling me to kill the cab driver, or you know, assault this one or assault that one, but it wasn't based on any crime in a relationship. It was based on a chemical imbalance in the brain that created a thought process that created auditory hallucinations that, in a command form, that led to committing the act. Is there a differentiation in your mind around the ability for a person, once they recompensate and reorder themselves psychiatrically, that a person with a crime of passion may be less likely to recommit a crime versus a person who did a generalized crime based solely on their mental health dysfunction? Is that a loaded question or what?
Well, it's a complicated. There's a clinical word for that kind of question. It's I can't find it. Let me unravel it a bit. Okay. In any event, because it's. I mean, this is fascinating. It certainly can fill a half-hour program. When you described that, when you framed this issue just now, you left out a middle category: the person who kills his mother, and in a close relationship, because hallucinations, God told them she's the devil.
Right, right.
That's, believe me, that is in a tiny, tiny percentage of people with psychotic disorders, that's a recurring neural connection, you know,
okay.
Chemical, you know, biochemical. So that's your middle zone.
Okay.
And you can't, a legal system that's based on, in a legal system, we do one fundamental thing. The point of it is to determine the person's moral culpability. And for centuries, our system of law, the Anglo-American legal codes, have recognized that when you kill your mother because the devil is in her, you're not as morally culpable as when you kill your mother because you're in a drunken rage. Mm-hmm. Or better yet, you kill your mother so you can get the life insurance. Mm-hmm. And that's exactly, it's so funny, when you're a lawyer, you actually spend your time parsing what's really bad from what's not that bad. You know, I find myself sometimes saying, that was a bad rape and that was a good rape, mm-hmm. with people over cocktails, because right. That is what lawyers do. That's what lawyers do, including prosecutors. Getting back to this, so it's a continuum, and we try to not to do retributive justice in our system. You know, we used to, as recently as the 18th century, we would cut off someone's arm for stealing, mm-hmm. and that's retributive beyond our modern ideas about justice and punishment. So you've got this thing of moral culpability that drives it, and you've got the sense that we want, that the whole point is to get away from retributive justice, so we have the rule of law. Mm-hmm. I mean, retributive justice is to some degree in conflict with the principles of rule of law. And there's, I'm leaving tons out here. There is penitence, and there is rehabilitation, and there's all these principles that have gone into our penal system since the late 19th century. Earlier, I won't go there. But so on this continuum, I as a lawyer who's been in this, I think the most reprehensible homicide offense is a contract killing. Mm-hmm. I think that's cold planning, terrible, really moral depravity.
No issue of competency there, though.
No issue of competency,
right.
and reason,
right.
and that person should receive a very, very long time in prison forever. Mm-hmm. I don't like anybody familiar with Rhode Island history. I don't believe in capital punishment, but I certainly accept life in prison without parole. Mm-hmm. I also think a governor has a role to play in pardoning people who actually do rehabilitate themselves. So anyway, so that gets us. That's at the one end. There's also the Timothy McVeighs. You know, someone who blows up a building, kills 130 people. Mm-hmm. Is that worse than a contract killing? those are both way out there. I don't think either. Timothy McVeigh for certain doesn't merit capital punishment in my book, because I'd like to study Timothy McVeigh for the 60 years he spends locked up in prison. It's worth knowing how that mind works, which is lost to us if we kill him. Then we get to mental impairment, and the law actually does make lots of evolving distinctions. I have a client who was mentally ill and drunk when he lit a fire that killed somebody, and the fact that he was intoxicated was more relevant than the fact that he was mentally ill, which means he was tried and punished and convicted and got a 35-year sentence for that.
And he's at the ACI?
No, he's now in a group home, actually. He finished his sentence.
Okay.
He finished his sentence and he was discharged into the mental health system because this is a man who could not live. He was very impaired. And last I knew, in a group home and committable, although this guy not committed, always voluntarily engaged in treatment, suffered greatly. I'm going to use tortured in prison. Forgive me, A.T. Wall, for using that word, but tortured. The prison is a barbaric place for a mentally ill person to be. And then he reached his flat date. That's another piece of prison world. Prisoners without mental illness tend to get paroled. Prisoners with mental illness serve to the last teaspoon of their sentence, because they don't know how to follow the rules in the prison, and they get sanctions, and
and parole is denied then at that point.
Yeah, denied. On and on. And that's not really, clinically speaking, for the community we work for and with, it's a little dumb that people should be paroled to group homes so that we have the leverage of parole. Once the sentence is flattened, it's done. Again, I guess that brings us a little bit to Mr. Woodmansee. What happened with him was, I think, this is the paper. I think that the prison produced psychiatrist whose opinion was that he was committable under the mental health law, based on I'll repeat, mental disability in need of treatment and unsafe in the community if unsupervised. And when presented to Mr. Woodmansee and his attorney, he elected to be voluntarily hospitalized. And beyond that, we'll go back to the generic. The state has the power to commit him to treatment should he ever refuse.
So we're covered in that regard.
Yeah, and a piece of this is a pleasure to be having this conversation, because I have great admiration for the mental health law. It's almost like a state secret, and that's partly because the mental health system is tries hard not to hospitalize. It's expensive. They don't use their legal authority especially when the newspapers aren't talking about it. But the mental health law itself is in place to solve most of these problems. I'm thinking now of repeat sex offenders. They developed this word which I despise called sexual predators, because that's just a way of rendering another human being into a subhuman, which serves no purpose in a rational discourse. But there is a community of psychiatry that has identified that group of people as having a pathology.
Unfortunately, we have already reached the end of this, and we are going to have you back again, because we've just gotten going, and it's time to stop. So I apologize for that, Reed, but we are now going to have to end our program today, and we will make sure we ask you back again, because it's just been insightful, and it's been a joy listening to you. So thank you again for being here, and thank you again for being on Minds That Matter.